But the courtroom wasn't done surprising anyone, because the next defendant didn't walk in with excuses. He walked in with confidence. He swore he was clean, swore he was working nonstop, and swore that court's test had to be wrong. But when the judge opened the report, even his own lawyer looked down.
On the record in the case of People versus Travis Oliver. Ma'am, I just remind you simply for the break that you're still under oath. Kate, you can continue.
Thank you, Your Honor. Hello again. So I believe where we left off was me asking that there was no video of this incident, and then you made us aware that there was a partial video, correct? And you previously testified, and you would agree with me, I have now reviewed the video. You would agree with me that in the video, Mr. Oliver is seen leaving in his own vehicle, correct?
He was backing out. He did not leave.
And in the entirety of the video, he is in his car, correct?
He was out of the car when my daughter was bringing her things into my car.
But you'd agree with me in the video itself. He was in his car the whole time in the video. And you would agree with me that the video does not at all show him opening anyone else's car door.
Yes.
And the video does not show him opening his own car door at any point.
Right.
And the video doesn't show him closing his own car door at any point, correct?
Correct.
So you'd agree with me that there is no video of his car door hitting your car door. I believe that would be all the questions for me. Thank you very much, ma'am. Thank you, Your Honor.
Can you redirect?
Just a few questions.
Why did you feel you had to start recording the interaction with Mr. Oliver?
Because I was not sure what he was going to do next.
And that video, at what part in the events of the 20th did that video occur? Was it the beginning, middle,
That
end?
was right after my daughter got in the car, we closed the door, and I was getting ready to leave. And he just kept on shouting things at me. So I thought, this is going to keep going, so I should record it.
And the video occurred after he hit your car door.
Yes.
Does it at you in a way that you perceived as being angry?
Yes.
Would counsel agree that's on the video?
I would agree, Your Honor.
I believe she tested or just stated that her opinion was that he was angry at her. I certainly would dispute if that was her feeling. I would definitely take objection to being characterized as Mr. Oliver yelling or screaming at all in the video.
Okay, so is there a reason I'm not seeing the video?
I would have no objection to its admission. I was
would have
not
no
moving
objection.
for its admission, however.
I mean, if you don't want me to see it, I'll just, oh,
We could-
that's fine. But I mean, part of it seems to me in this is one's motivations for doing what they're doing, so.
So you took a video on this date, and did you provide the video to the prosecutor's office today?
Today.
Today.
Yes. Yes.
And was the video you provided the video we were just discussing?
Yes.
And Your Honor, the people would.
You have cable? Is there a cable down?
Yes.
If I may, the police officer that came to help, she saw the video from the gas station. She went to the gas station and saw the video, but I don't know what happened to that.
From BP?
Yes.
Is there any indication that that was preserved?
I have not seen the BP gas station video.
Pardon?
I have not seen the BP gas station video, Your Honor. I don't believe that was.
I have not either. I do not believe either party has it. And this is a proper proof to the court and review the body cam video of that office in my review
Your
of the
Honor.
body cam video of officer talking that attended. I
do not believe that that video has ever been turned over to the
And it was not
prosecution.
mentioned in the report, Your Honor, the video.
Okay. All right. She's ready.
Is what's on the screen, is that a fair and accurate representation of the video that you provided today?
Yes.
Your Honor, the people would move to admit people's proposed exhibit 2.
No objection, Your Honor.
Exhibit 2 is admitted.
May we publish to the court, Your Honor?
Yes.
I think my volume. Oh. Your Honor, if I could have one moment.
Pardon?
I have one moment, Your Honor.
The judge called the next name, Kyle Becker. He stepped forward, like a man who believed the system had made a mistake, head high, voice steady, ready to defend himself. His attorney requested a short adjournment, explaining they still needed time to review new evidence. But the judge had already seen the violation report, and nothing in it matched Becker's confidence. Missed check-ins, ignored instructions, a positive test he insisted wasn't his, and a job schedule that somehow kept him from testing, but not from getting in trouble. The judge flipped through the pages slowly, almost giving Becker a chance to speak up, but he stayed silent, hoping the paperwork would save him. It didn't.
And Your Honor, I did want to correct the record. There was mention of the BP gas station video, but I do not believe we ever received that video.
And I would agree with Ms. Zenda that I do not believe that the prosecutor's office has ever received that. And I have certainly reviewed it. And based on my review of the other discovery, I would not be surprised if the Pittsville Township Police Department also have never received it either. They tried.
Well, it mentions the video. But-
Yes, Your Honor, in the report, but we never received a
Does
video.
it exist?
I don't
So-
That's the question.
This might be a little clunky, but frankly, in the review of the body cam video, the officer did speak to the gas station attendant who said, I can submit that to you likely tonight. I don't know if it's gonna be during his shift or after. He said it saves in our system for 7 days. He would have to be sending it to an iPhone, and the video, the body cam ends with the promise that he was gonna be sending the video.
To the police.
Yes, so I don't know if they ever received.
No. So why don't we contact the police and find out if they have the video?
I can call the officer, Your Honor.
All right. Why don't we do that? Was there any other questions of this witness? All right. Any questions?
Nothing
No
further, Your
questions?
Honor.
Okay, you may step down. And while you guys try to figure that out, we'll take a brief break in this and figure if we have the video. Otherwise, I'll just call it on. Is there going to be any more witnesses for the people?
None from the people, Your Honor.
All right, at this point. And I will wait to ask if there are witnesses for the defense until we figure out if the video's there. Okay. All right, I'll pass on this matter. I'll take care of some other matters and let's figure that out, and then I'll come back to it. Hey. But I don't have, you know,
Yeah, the one we have.
attorney for Bodman here yet? Oh, oh, there she is.
All your. The only affirmative case left.
Left.
Yeah.
So no dismissal came in on
No, I've received the other 9. This is the only one I have not received yet.
that. All right. You guys ready? Arbor One West and Arbor One versus Rico McGuire et al.
Ellis Friedman for the plaintiff.
Henry, I'm the defendant.
Okay.
Randy Barker, city attorney for non-party city of Ypsilanti.
Okay.
And Travis Gagne on behalf of Beal Properties.
All right. Where are we?
Your Honor, you ordered and kind of, we all agreed to have a meeting to try to work on a schedule and a plan and some deadlines and so on for permitting, construction, inspections, et cetera. That meeting took place yesterday at City Hall, and it was, I would say, very productive. Schedules were set forth, agreed upon. Protocols were set forth and agreed upon. We're shooting for, I think it's the 20th. Well, could I let Ms. Gordon-Leman do the particulars?
She's gonna talk anyway.
Okay. We'll let her start right now.
Yeah.
So yes, I was here and that meeting, it was very productive, good progress made, everybody left the meeting saying the same thing. We went through, I know one of the things we had discussed after hearing.
we thought we had resolved kind of came about again last evening in an email exchange, and that involves the testing for the mold in these units. And our resolution, to I guess resolve some of this unpermitted work issues with mold contaminated drywall or wet drywall that need to be replaced. You need a permit for that. Was that they would do the unpermitted work. They would do what's called a scope or a probe type of air quality test, just at very least to satisfy us for purposes of our inspection, purposes of our certification process, that the black mold that seems to have been stigmatizing and permeating these buildings and all the other ones has been remediated effectively. You can't get rid of all of it. We understand that. There's also natural outside molds that are not toxic. We understand that too. But that's what we thought we had going on yesterday is this happening. And that was because of the report that was shared with us by the landlord with recommendations that each unit be evaluated for mold based on the testing, particularly based on testing that showed that the units that didn't have indicia of mold or where it was visible, in some cases, we're actually testing higher than where we knew where it was. So that seems to be our sticking point that we're trying to work through. And that resolution was in lieu of addressing some of the headaches and the additional costs of tearing out unpermitted work so that we can perform the inspections of the root cause of the mold moisture being resolved. So that's where we're at. I thought yesterday's meeting was incredibly productive. Of course, there was some tumult at the beginning that everybody worked through, which is what happens in these types of meetings. But the fact that you were called yesterday, I think should be, something that the court should be fond of. But that seems to be our only issue, and it came up after the fact, after everybody left the room, went home for their day.
And so I will say, response to what Mr. Barker said was, so as a part of the correction orders issued by the city, if they notice mold, that's something that is being remediated as part of the COC reinspection process. So they're following the process of the standards necessary to remediate the mold city noted. That's been done. So when they come back for reinspection, if it said there was mold in this unit, that's been taken care of. As Mr. Barker also indicated, there was some concern about work being done without a permit, so that they weren't able to necessarily verify whether or not there was an issue in that area with mold before the work was done. So, and an abundance of caution to ensure that we're not ripping out work that's already been done, we've agreed to do the limited scope test in that area. So at this point, we're taking care of the mold that we've noted. We're doing the scope test for areas that you have noted there were concerns and there's work without permits. But the city is asking us to do air quality tests in all units, even units that they didn't know mold was in. And so while this didn't initially seem unreasonable, we've learned that information from the county level, from the county health department, that they don't recommend this type of testing because it's unreliable. You can have mold coming in, airborne mold from open window. It can be from, plants. It can be from living conditions. It can be from anything. So you test for air quality mold in all those units. Some you may get some hits, some you may not. So if the goal is seeing if there's mold in these units, we're
well, where is that request? Where is that the city's position that the mold that testing needs to happen?
Well, actually, we're getting a different bit of feedback from the county health department because of the how aggressive the mold was in all of these buildings. And mind you, the reports that were done initially were actually produced by the landlord, except for these two buildings. It's apparently almost.
No, I understand all of that. I guess what I'm getting at is, what is county health recommending? Because I know in other cases that testing, you're right, they don't recommend that testing because it may or may not tell you anything.
It's what you're testing for. Mr. Myers is here. He actually spoke to the health department this morning.
Good morning, Judge. I had a lengthy conversation with Christian Swire. And on the county's website, it does indicate in typical circumstances that indoor air quality isn't recommended. However, with the conditions of these buildings, she would definitely recommend indoor air quality testing due to the nature of the report that was submitted to the city by the landlords, as well as the mold conditions that she has observed on the property. I'm waiting on getting an affidavit from her. They're checking with their legal counsel right now on the condition of mold out at this property as being a concern to the county health department. And so while in very typical average circumstances, it would not be something they would recommend. In this case, that is not the case. And this is not the case in this particular matter.
All right, so I guess then my question would be, if county health says this is recommended, is it going to be done?
I mean, my understanding as well is that if